This past week, I was contacted by a potential client, and we were discussing a solution for her husband to obtain a green card. It was the I-601 provisional waiver. And the main theme of our conversation was as follows. How can she demonstrate extreme hardship in order for her husband's waiver to get approved? And these were some of my thoughts. Extreme hardship must be demonstrated to the U.S. citizen, not the foreign-born spouse. Some examples of extreme hardship are medical hardship. If someone routinely sees doctors here and needs ongoing treatment, that could be considered medical hardship. If the spouse were to be separated and living in another country, or if the U.S. citizen were to be forced to follow them to the foreign country. Also, financial hardship could be taken into consideration if the spouse is a primary breadwinner. Also, psychological hardship, that was a big factor. Suppose someone has suffered throughout their life, possibly because of prior relationships that were very difficult or a childhood that was very difficult. If the spouse were to be separated from them and stuck abroad, that would be extreme psychological hardship. Those are some examples of hardship. There are many others, but those are typical examples. So once extreme hardship can be demonstrated, there is a very good possibility that the 601 waiver will be approved. Your spouse who came across the border will be able to travel to the U.S. Embassy back home, successfully obtain a visa, re-enter the U.S., and the green card comes in the mail. If you have any questions about this or any other immigration questions, please feel free to contact my office in Morristown, New Jersey, and I will be happy to talk to you and hopefully resolve your question.